All right, guys. How you doing this evening? This is the Dark Angel, and this is I am the host of Freedom is a Choice channel over on YouTube, and as well as this channel here on TikTok. And today, what I'm going to get into is this video is actually for all the naysayers out there who never believed that the right to travel in your own private automobile was actually the law back in the day. It still is the law, but you know, there's a lot of naysayers out there who don't believe it. So I've done videos on my Freedom is a Choice channel in reference to these cases. So I'm going to bring them here to TikTok. And basically, what I'm going to do is I'm going to tell you the name of the case, give you the date, okay, of the case, and then I'm going to read the opinion from the case, okay? And that's going to be it because these going to be some short videos. I don't want them to get too long-winded and anything of that magnitude. So as you can see, I have law book right here, okay? 100% case laws right here in front of me. Those of you that do know me and follow me over on my YouTube channel, you do know that I spend my days in an actual law library. And I research, read, copy, and print the laws straight from the books. That's what I do. So I've been doing for over 40 plus years. Well, 50 now, and it's what I do. Okay. And I carry these binders, which I have tons of them, in all my vehicles. And the reason for that is because We the People van travels all across the United States teaching this, holding seminars, litigating for people. And I try to help out as much as I can. So, the first state Supreme Court case that I'm going to introduce you guys to is called the City of Chicago versus Collins. Okay, 175 Illinois 445, dated October 24th, 1898. Okay, so, and basically what I'm going to do, as you can see, I'm turning the pages so there's no bull crap in here. And I'm taking you straight to the opinion in the case. Okay. So, Justice Phillips, who handed down the opinion in this case, said the following. Okay. So, before I get into that, so as you know, there's two parts of the regulation, okay, that has ever been presented in any state in the United States. It's two parts. The first part, as Justice Phillips says, is the city may regulate the use of the streets and alleys to the extent that it may require sidewalks exclusively reserved for use by pedestrians, and exclude certain characters of loads and regulate the width of tires on vehicles used on a certain character of pavement, and provide that the rate of speed shall be much less on certain streets than on others. That's the first part of that regulation that applies to everyone, whether you have a license or not. And otherwise regulate the use of the streets, having in view solely the welfare and safety of the public. Now, listen to this, guys, because this is the law and this has never been changed. This is in every standing law to this day. You go in and you read your sessions laws, and it's still written this same way. The city may also regulate certain occupations. occupations, such as hackmen, draymen, expressmen, and the like, for such regulation is of a police character, meaning the police power. Okay? Having reference to the general welfare as a means of preventing improper exactions and extortions. And for the same reason, here we go. A license may be exacted for vehicles used in the transportation of goods and or merchandise and or passengers, or for other purposes of traffic. But such license is an occupation license and not one for the use of the streets. The license in the latter named case is designed to operate upon those who hold themselves out as common carriers, such as taxis, limos, stagecoaches back then in that day, police cruisers, tow trucks, fire trucks, ambulances. That's what they're talking about. Want proof? Here you go. Common carriers, and a license may be exacted from such as a proper exercise of the police power. But no reason exists why it should be applied to the owners of private automobiles used for their individual use exclusively in their own business or for their own pleasure as a means of locomotion. For all you naysayers out there, I told you that locomotion included private automobiles. And this was a case written back in 1898. Imagine that, people. Imagine that. Now we're going to move forward, okay? We're going to come forward 5 years, I'm going to guess. 5 years. To another, oh, and also in that Collins case, to reiterate on what I was reading to you guys, I meant to mention, you can also look up these other state Supreme Court cases. I'm only going to name a few of them, but it has tons of them in here from all the states, all 50 states around the country. And at that time, in 1898, we didn't have 50 states. So, Farwell versus City of Chicago, Joyce versus City of East St. Louis, City of Collinsville versus Cole, City of St. Louis versus Grown, Livingston versus City of Paducah, Kentucky, City of Covington versus Woods. And that's just to name a few. Now, this judge is telling you that the reason why a license isn't necessary for private use of automobiles is because the right to locomotion, fundamental right, okay, by and through the 10th Amendment, given the power to the states and or the people, does not have authority to take away the rights that's delegated to the people pursuant to that of the 9th Amendment. Oops. And a lot of you naysayers believe that this 10th Amendment has this unprecedented power for the state. But no, the 10th Amendment does not give the state the authority to override the 9th Amendment. It does not give the state the authority to take all rights that are mentioned, enumerated and unenumerated, under the 9th Amendment that was given to the people, delegated to the people, the authority to take those rights and regulate them. They are fundamental rights and they cannot be regulated. So there's your proof right there, 100. But I'm going to, like I said, I'm going to take you on into coming closer to our time, and I can actually bring you all the way up to the 60s with this. But I'm bringing you this because whenever you challenge a statute and or a state's law for requirement of a license, it becomes ambiguous. And it becomes ambiguous because the states say one thing where Supreme Courts and the Supreme Court says another thing. Okay, so in order to resolve that issue, the Supreme Court, looks to the historical aspect of the license. And as you will notice here, there was no such thing as a license when automobiles first came out. And the laws specifically stated that the only part of the regulation that applied to that of people driving their personal private automobiles was the speed, the weight, the height, the width, the tire width. Sorry, it's the facts. So the next one is City of Chicago versus Banker. In this case, it is from 1904. He lists so many other state Supreme Court cases. And what you have to be aware of is the fact that the one common word that is associated with every single case all the way up until today: locomotion. Just saying. So, what we're going to do is we're going to go to the opinion in this case. And we're going to read it real quick. And actually, I just now realized this myself, because I didn't even really remember this being in here, but it actually is in here. This Banker case references the Collins case. In the City of Chicago versus Collins, 175 Illinois 445, a bill was filed by 373 residents and taxpayers. Okay, they asserted that the city had no power to require a license for the use of private vehicles upon the streets, nor to impose a tax thereon by way of license. The court held that the right to travel being in the general public everywhere, all persons have a right to pass along and use the streets and alleys of the city in all their parts. And you guys need to keep this in mind. This is still written in the law today. For those of you who actually sit down and read. Full length and width thereof, that any method of travel may be adopted by individual members of the public, which is an ordinary method of locomotion. Now, ordinary method of locomotion is a personal private automobile, or your personal horse, or your personal steam engine car, electric car, whatever you have that is your personal use, that you are not asking for a fee, that you are not receiving some type of compensation from. Okay, watch what it says. Watch what it says, because it still says that today in all the laws today. Okay, so public, which is an ordinary method of locomotion, or even an extraordinary method, that is the ones who are getting paid. Okay, if it is not of itself calculated to prevent a reasonably safe use of the street by others, that the power given to the city to regulate the use of the streets is conferred by 97. The purpose of keeping them in condition for public use and travel. Public use is anything doing commercial or commerce. Okay? In the event that you didn't know the difference between that. Travel is the private. Okay? Let's see. Keeping them in condition for public use and travel. That any usual method of travel along the streets cannot be declared a nuisance. That the regulation as to speed of travel is for the safety of the public. That's there you go again. That's that part of the regulation that applies to everyone, licensed or not. Okay? So when I tell you guys, and I have been telling you this for years, there's two parts to that regulation. But you guys fail to want to hear me. Traffic lights, stop signs, speed limits, etc., etc. That's part of the regulation. Section whatever. Okay? And then there is the commerce governed section, the license. You're doing business on those streets, you need a license. Period. End of story. That has never changed. It's still written in the law today. I could take you up to 1915, where the Sessions laws adopted or enacted the true definition of a motor vehicle as that being used for commerce and commercial activity. Nowhere in there does it say anything about a private automobile. Anyway, moving forward, the regulations as to certain occupations, there you go again, such as a hackman and others having vehicles for hire, proof right there, what I just said, are occupational license only and are an exercise of the police power. See, the police only have the power over occupation license. They assume that when you are traveling in your automobile that you are under occupational license only. They assume this. No, you are not. That a license implies a privilege, something that cannot be enjoyed without legal authority and cannot be demanded for the exercise of a right. Did you hear that? A license cannot be demanded for the exercise of a right. Your right to locomotion includes you being able to operate your own personal private automobile. Facts. 100. So for all you naysayers out there who don't know the law, you might want to try and sit down and actually pick up a book or two. Let's see. Okay, so, and cannot be demanded for the exercise of a right. Free and open to all. Oh, wait a minute. That's written in the Sessions laws. To this day, I will pull out a 2020 Sessions laws and show you where those exact same words are written in law. As is the right of the citizen to ride and drive. Oh, did you hear that? As is the right of the citizen to ride and drive over the streets of the city without charge and without toll. Now, here's something you have to keep in mind now. There's some things are a little different these days because of the simple fact is toll roads are often bought by private entities. So the rules change when that happens, okay? Provided he does so in a reasonable manner, and that the authority upon the part of the city to impose a tax and or exact a license must clearly appear and must be strictly construed accordingly. The Supreme Court affirmed the decree of the trial court, which perpetually enjoined the enforcement of the ordinance. Dun, 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 dun. Moving forward. The Supreme Court held that laws which interfere with the personal liberty of a citizen and with his right to pursue such avocation or calling as he may choose cannot be constitutionally enacted unless the public health, comfort, safety, or welfare demands their enactment, and that it is the duty of the courts to determine whether or not a law impairing the right of a citizen to follow his individual preference in the choice of an occupation comes within any of these exceptions. Then follows a review of the facts from which the court finds the Act of 1897 to be invalid, and the judgment of the trial court is therefore reversed. In the case at bar, the right of the appealee to use the streets is undoubted. It is true that he must use them without interfering with the safety of others in the exercise of the same right. Subject to that limitation, his right cannot be regulated by an ordinance. Now, ordinance, if you look it up, that's a rule, policy, law, if you want to say, etc., etc. So when they tell you, well, it's the law, it's a statute. Well, an ordinance basically is a statute. They're the same thing. So there's that for you. The fact that the automobile is a comparatively new vehicle is besides the question. The use of the streets must be extended to meet the modern means of locomotion. And you can find that in a case called Moses versus PFW and C Railroad Company, 21 Illinois, 515. Okay? Moving. Moving. Okay? The speed of the automobile, here we go again, here's that first part of that regulation. The speed of the automobile may be regulated, and reasonable safety appliances such as gongs and brakes, headlights, tail lights, blinkers, turn signals, brakes, etc. This is all part of that first part of that regulation. May be required. But to compel one who uses his automobile for his private business and pleasure only to submit to an examination and to take out a license is imposing a burden on one class of citizens in the use of the streets, not imposed upon the others. We must therefore hold that this ordinance, so far as it obliges appealee to take out a license before he can use his own automobile in his own business and or pleasure, is beyond the power of the city and the state, and is therefore void. Word for word, right from the laws, guys. Word for word. So I did a little analysis on this, my own personal analogy and analysis. And this is what, Dark Angel's emphasis of facts. So you ask, how is driving a right? Simple. The 10th Amendment, once the Supreme Court ruled that driving was a right, it became an unenumerated right. Rights not founded in the Constitution are protected and guaranteed by the 9th Amendment. Not the 10th Amendment, guys. The 9th Amendment. Rights delegated to the people are fundamental rights under the word locomotion. Or that document, also under the Latin legal maximum expressio unus este exclusio autorius. You know what that means? That's a legal Latin maxim. And what it means is the uniform rule that the express mention of one thing, motor vehicle, it is the uniform rule that the express mention of one thing in a statute implies the exclusion of all others. All statutes mention only motor vehicles. None of them mention nothing about private automobiles. Just saying. So, and you can actually find that in Port of Seattle versus Department of Public Services, Washington, 1 Washington 2D, 10295, page 2D, 1007, 1939. Now we done came up 30 odd more years. Yeah, you heard me. 1939, and personal private automobiles still don't require a license. Personal private automobiles is not included in any state statute. So there you have it, guys. Now you know. You've been educated. Get these two cases. City of Chicago versus Banker, City of Chicago versus Collins. Collins is the 1898, Banker is the 1904 case. Follow up with the cases written within the case, and you'll see that every state fell under these laws because it was the law. It still is the law, but they choose to ignore it and try to brush it under the rug. The law has never changed. So, next video will be right here. This right here, what I'm holding in my hand, is a photocopy of the state sessions laws in 2020. Next video. Dark Angel, deuces.